Donald Trump had some major losses this week in court. He lost before the United States Supreme Court in a 5-4 decision where Donald Trump was trying to block his criminal sentencing in the Manhattan criminal case where he was convicted on 34 felony counts. The sentencing did indeed go forward, meaning Donald Trump is an adjudicated felon. I want to talk about that, Trump's other losses as he appealed to the Supreme Court to try to block this sentencing. But when we talk about the United States Supreme Court ruling, we should talk about this 5-4 dynamic. You know, Justice John Roberts and Justice Amy Coney Barrett ruled against Donald Trump. Are we seeing a new alignment of certain right-wing justices who will be joining with the liberal justices and forming a new majority for some cases where Donald Trump will try to engage in constitutional excesses? We will break that down. We'll talk about the Supreme Court oral argument in the TikTok case. Not good for TikTok at all. To me, the question is, will it be a 9-0 ruling? Will there be some other kind of formulations of joining opinions that somehow soften the blow? But it does not look good for TikTok if you were listening to that oral argument, and that's an understatement. Let's also talk about the DOJ reports on Donald Trump's criminal conduct, from the Mar-a-Lago case to the Washington, D.C. federal criminal case. The report is expected to be released soon. Donald Trump tried to block that with the 11th Circuit Court of Appeals. He failed there. We'll talk about that. Also, let's talk about Rudy Giuliani being held in contempt once again, this time by another federal judge. You know her, you love her from listening to Legal AF, Judge Beryl Howell out of Washington, D.C. And if you're saying, deja vu, didn't you tell me that Rudy was found in contempt last week? Yeah, this is kind of the Rudy roller coaster. Instead of going up and down, it's just going in one direction. Contempt, 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 contempt. We'll talk about all of this and more. This is Legal AF. I'm Ben Meiselas, joined by Michael Popok. Start with just saying that my heart goes out to everybody affected by these horrific fires in California. I'm still evacuated, although I'm hopeful that I'll be able to return. But I certainly know that there are many who will not be as lucky as I am here. Many have lost everything in their lives, and my heart goes out to all of them. It's been a very tough week for us here in LA and California. And I'm not just thinking about California, though, too. Anybody who's going through tough times, whether it's a natural disaster or otherwise, our hearts are with you in these days. Bye-bye.
Yeah, I join you. We did a similar shout out or support for the New Orleans massacre. The fires, you got my love and support there for you and your family, your extended family. Everybody knows somebody that's been impacted horribly by the fires in California. It reshapes our relationship with our planet, with our weather, with our neighbors. The only time I've ever felt like this exact feeling is when my friends in Florida suffered through Hurricane Andrew, which changed life as we knew it in Florida for that time. And I have a very similar set of feelings about what you and others are going through there. So we've got, just before we could jump in here, as you led off, we just broke a 249-year unbroken streak of having felons as president. And we'll talk more about that. Well, I guess we'll just start all over again. We'll see what we can do for the next record. And while we look at the lashing out and acting out by Donald Trump at his sentencing hearing, we'll talk about that next. Contrast it with an extraordinary set of achievements by the outgoing president, Joe Biden, that's not getting as much attention as it should. I mean, this is forget lazy or slow Joe. The amount of things that they have been able to accomplish just in the last 10 days, 330 million more acres of natural wildlife refuge are under protection to protect it from Donald Trump's drill, baby, drill. 1,400 people granted clemency, more to come, and expanded temporary protected status that's going to be hard for Donald Trump to overcome, affecting 1 million people here from Ukraine, El Salvador, Venezuela, Sudan, and the rest, all with a stroke of a pen. We've got the TikTok ban, which you and I are going to talk about, sanctions against Russia and its oil company as they continue to try to help Ukraine in its war there, sanctions against China. We'll talk about TikTok again. And you also have an announcement in the last 24 hours by Secretary of State Blinken that they are close to being on the verge of a complete hostage release between Hamas and Israel, all in the waning days of the Biden administration. Extraordinary.
Which, by the way, you have this contrast between President Biden, head down, speak soft, get things done, don't brag about your accomplishments, do it for the American people, and focus on, again, just keeping your word. On the other hand, you have Donald Trump, brags about everything, takes credit for things that are undeserved, loud, obnoxious, but when it comes down to it, is someone who doesn't keep his word, who doesn't execute on things, and ultimately, if there is a Gaza deal, what Donald Trump's setting up for is to take credit for it. They did that because of me. This happened because of me. That happened because of me. And I recall him saying on day one after the election, there was supposed to be peace in Ukraine. That's what he said. He said that he would have already had that done already. He said he'd go to Putin and say, blah, 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 blah. And I'd go to Zelensky and go, blah, 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 Zelensky, make a deal, make a deal. You make a deal. You like each other now. Deal. Well, that didn't happen. You want me to give him the benefit of the doubt, which I shouldn't, and say he meant 24 hours after the inauguration? Well, where's that meeting? When is that happening? Doesn't seem like that's going to happen. All
Never.
is the opposite. So, and also, all this rhetoric of Donald Trump talking about invading Greenland and Panama and annexing Canada and Mexico and all of these things, I've called it a WMD, a weapon of mass distraction, a WMD, a weapon of mass distraction. We have to take that stuff seriously. But I always go back to, okay, well, how is this going to lower prices? How is this going to make housing more affordable? How is this going to lower interest rates? How is this going to lower mortgage rates? How does any of that have anything to do with anything you said during the campaign? And it hasn't. So we need to take certain things very seriously. But what we can't do is what happened in Trump administration 1 and what happened a lot during the campaign. There were all these shiny objects. We get distracted. We're looking here, there, and the other places. We have to be focused and we have to control our narrative, which is the truth, and saying, how is this impacting the American people, and stop falling for all of the shiny objects, though we should take it seriously. With that said, let me just get into what's going on in courts. So Supreme Court 5-4 decision against Donald Trump when Trump tried to block his sentencing. The sentencing ended up taking place on Friday. Recall, Donald Trump tried to block sentencing at the trial court level before Justice Merchan, denied. At the appellate division level, denied. At the New York highest court level, which they call the Court of Appeals. They call their Supreme Court the Court of Appeals in New York, which just makes things confusing. And their lower court's called the Supreme Court. Go figure. Anyway, New York's top court, they reject Donald Trump. Trump goes to the Supreme Court, 5-4 decision. You have Justice Amy Coney Barrett and you have Justice John Roberts joining with Justice Ketanji Brown Jackson, Justice Kagan, and Justice Sotomayor. Those last 3 justices that I mentioned were appointed by Democratic administrations. Justice John Roberts was appointed by George W. Bush. Coney Barrett was appointed by Donald Trump when Ruth Bader Ginsburg passed away. We saw in Amy Coney Barrett, she actually joined with some of the justices who were very critical of the 14th Amendment Section 3 case as well. Remember back in March of 2024 when the Supreme Court unanimously ruled that Colorado could not disqualify Donald Trump from the ballot, but then they divided on what the 14th Amendment Section 3 meant. The Supreme Court's majority went a step further, and they said that actually it's not self-executing. Congress needs to pass a law if you want to do a disqualification. Coney Barrett joined again with Ketanji Brown Jackson, with Justice Kagan and Justice Sotomayor, and they said, whoa, why are you shutting the door to other ways of dealing with the 14th Amendment Section 3? You're going way too far here. We agree that Colorado couldn't do the disqualification, although states can disqualify state officials. States can't disqualify federal officials all the Supreme Court justices said, but why are you going out of your way to help Donald Trump in ways that aren't even part of the briefing? So you saw that coalition form there with Coney Barrett being kind of peeled off there. One point I want to make is Justice Amy Coney Barrett, she was a professor at Notre Dame Law School. Her whole thing was getting rid of Roe v. Wade. That was her life's work. If you read her readings, you knew that she was ultimately going to do everything in her power to get rid of Roe v. Wade. We can hate that. We can despise that. We can be as critical as that as we want to be. And we are here on the Midas Touch Network and on Legal AF. But as it relates to other issues, Michael Popok, she was not really in that Federalist Society kind of clique. That's not her crew. She seems to be very uncomfortable after Donald Trump kind of paraded her around when he selected her and brought her to the White House, and kind of that real creepy display and kind of, the way he just strutted her out was very strange. And I think she's always been resentful of that. And I think she doesn't really like Donald Trump, if I'm being totally blunt, reading between the lines and seeing some of the times she's spoken at places. So can she be joining now at some of the other justices? And is Justice John Roberts, remember last week, this is why you got to watch all the Legal AFs. We talked to you about that report that Justice John Roberts wrote, that annual report where he talked about the threats to the judiciary, and he seemed to basically be subtweeting or subposting or basically talking about Donald Trump, disinformation, threats of violence and intimidation, not enforcing the Supreme Court's will and the Supreme Court's order. Is he standing up right now and saying, look, we gave you a lot. We gave you absolute immunity. We ruled on your favor, 14th Amendment, Section 3. We've given you a lot of what we wanted as the Federalist Society in terms of, getting rid of the Chevron doctrine, essentially getting rid of the Lemon Test, separation of church and state, really neutering the ability of agencies to do work. But don't go a step further. We've done that. If you start going there, we will rule against you. Was he sending a message? So, Popok, I want you to talk about the sentencing, because I'm not talking about, you'll cover that aspect. But I think before you talk about what actually went down in the sentencing after Trump lost in the Supreme Court, which opened up the sentencing to take place, I think that dynamic is an interesting one that we're going to see over and over. So I think it's worth talking about.
Yeah, and on Unprecedented, the show that Dina Dahl and I are doing on the Legal AF channel, we're going to get our unprecedented week look at the Supreme Court up, I think, today. One of the things that I outline is, and we started from last year, is the rise of Amy Coney Barrett, centrist, right center. And we said, keep an eye on Amy Coney Barrett throughout the rest of this term and beyond, as she kind of comes into her own. Sure, she sided with the majority in the immunity decision and a number of other decisions that we don't like, especially as it relates to church and state, especially as it relates to reproductive rights. She was not a reliable vote for women or for secularism or the separation of church and state. But now that we've gotten some of those out of the way, she is, it appears to be willing on a number of occasions to not only side with the Democratic wing of the Supreme Court, but also to chastise and take on Alito and Thomas and even Gorsuch now, who's becoming a reliable third vote over on the alt-right extreme of the Supreme Court. I'm talking about Gorsuch there. So Amy Coney Barrett criticized a number of things that Clarence Thomas has been using, like gun control. She didn't like the way he's using historical precedent to kind of bind the court to 1800 thinking, and attacked him for that. So we saw the beginnings of this. And we also thought that relationships get formed on the Supreme Court, and that perhaps because the only other three women on the court are on the Democratic wing, that maybe there'd just be some natural affinities that would develop over time, being the four women on there. And whatever the combination of reasons are, we are now seeing what I think is the rise of the Amy Coney Barrett court. And every time we have a centrist or it's the last 50 years, it's a Republican, because look, it's been Republican controlled for over 75 years. The unbroken string of Republican presidents for a long time, and then a couple of others and Democrats. We had a long block of just Republican presidents picking the Supreme Court for most of my young adulthood. On the Amy Coney Barrett side, or the centrist side, let's start with Sandra Day O'Connor, right? But she's center. Then we get Kennedy. It became sort of the Kennedy court for a long time because his fifth vote mattered. He was in the majority more than any other Supreme Court justice for the bulk of his tenure there. But he was to the right of Sandra Day O'Connor. And now if Amy Coney Barrett becomes the one who votes in the majority with most of the decisions, making her the swing vote, she's to the right of Kennedy. So we're watching the center right going further right, of course. But if I'm a Supreme Court advocate, I got to aim for Amy Coney Barrett. I said last week when it came to TikTok and sentencing that it's going to be Amy Coney Barrett on sentencing, trying to bring Roberts over, not to touch the immunity decision another time. He's already circling the drain of history for the first time he touched it, and bring them over to the Democratic wing. I thought Kavanaugh maybe, but he's becoming a foregone conclusion to side with Gorsuch more than he sides with the majority on opinions like this. So I think you're right about Amy Coney Barrett, and we'll see it also in the TikTok when we give our review and analysis of the oral argument about the TikTok ban, because she was very vocal and very active there. I'm not saying, though, I don't want the impression to be that I'm a huge supporter of Amy Coney Barrett or, she's covering herself in glory with a lot of these decisions. She's not. And the intellectual heavyweight among the court for me of newly appointed justices is Ketanji Brown Jackson. But the problem is Ketanji Brown Jackson is on the Democratic wing that only has 3 people. And you got to count to 5 in order to have anything happen on the Supreme Court. So in the sentencing, the way that all backed up there is, look, this should have been, Dina Dahl was right when I talked to her yesterday. This should have been 9-0 against Donald Trump. This is a garden variety prosecution where immunity as an issue in the Stormy Daniels hush money conspiracy case for which Donald Trump is now a felon, the immunity issue was not front and center. He had already waived the argument in prior briefing that his actions at the heart of the conspiracy were immune. They were only left with a secondary position within the immunity decision from the Supreme Court that certain evidence about official conduct, if it is official conduct, while somebody is president, can't be used to prove the rest. And the question is, did any of that come in through the filter of Justice Merchan during the trial? And if it did it matter? Or was it harmless error, not reversible error? A very discrete, arcane, evidentiary issue, academic issue. And let's get to sentencing. Get the judicial decree that declares him to be a felon. Let him take his appeal in the state court system, where it belongs. Exhaust that appeal. And if anything is left over on immunity, then run it over to the Supreme Court. That should have been the decision of everybody on the Supreme Court. It did go to Sotomayor first, as I had thought, because she sits over everything in New York as the assigned justice for the New York region. She referred it over to the rest of the panel because she didn't want to be caught, with a shadow docket problem of her making the ruling. She could have made the ruling on her own, like rejected, and then we'd be talking about it in a different way. So she referred it over, took a risk. It looks like it was a risk. And then they started, after full briefing by the Manhattan District Attorney's brief, and then John Sauer, the soon-to-be Solicitor General for Donald Trump, but currently his private criminal appellate lawyer, he argued. And I read that brief, you read that brief, and everything, nothing in there was legitimate or had any intellectual honesty about the state of the law, even after the immunity decision or anything. President-elect immunity, Supreme Court, five of them did not buy that he currently has immunity from anything. That this immunity issue it needed to be resolved right now before the completion of the case through sentencing and appeal in the state court. No, they're not buying that. And that's where the mastery of Justice Merchan comes into play. We're going to talk about a couple of places where there's genius at work. At the 11th Circuit about the DOJ's position about the release of the special counsel's report, and something they did there that was masterful, which we'll we'll flush out here. But Justice Merchan, in retrospect, he made his sentencing decision Supreme Court proof. Because the first thing they latched onto was the thing that we were most upset about, that he wasn't going to sentence Donald Trump to prison. And they said, right, in their decision by the 5 of the Supreme Court, they said, and you're not even going to prison. So you don't really have a huge prejudice or impairing or impeding your presidency because you're not going to prison. Go finish your appeals. If you got any issues after your appeals in New York, come back to us on a better record, but not this. And that got the 5 votes, the 3 on the Democratic wing. Roberts, who's like, I assume he's like, I don't need to touch the immunity decision and be accused of helping Donald Trump one more time in this area on this issue of evidence. And that was it. And then that was Thursday night, late. You and I were reporting on it in various ways. Friday morning, up and running. Justice Merchan with what? And I'll give you get your comment on it. You listened to the audio too, which was a lot of meh. Like it was a very anticlimactic ceremony around this virtual sentencing of Donald Trump to no jail time.
The other thing that Justice Merchan did, in addition to pointing out he was inclined to order this unconditional discharges, he said that he would make the appearance accessible to Donald Trump by Zoom or by, virtual means, which also Justice Merchan knew what Trump would argue is you're preventing the transition from taking place. I now have to fly to New York, and this is a precious day. Obviously, we know that it's BS. Donald Trump would probably be golfing or listening to the Beach Boys at Mar-a-Lago and not doing the things that he claims and promised he was going to do. But he would make that argument nonetheless. So Justice Merchan said, look, it's going to be a relatively short hearing. I'm inclined to grant an unconditional discharge. But there was a broader principle that Justice Merchan was trying to save, which is the jury verdict, the rule of law in the sense that there was this verdict. And Justice Merchan, I think, recognizes, too, that he would have had the ability here to chip away at this absolute immunity doctrine and show that specifically what happened in this case, what happened in the New York hush money, business records case, fraudulent business records, falls outside the outer limits of any absolute immunity. So this case, if Donald Trump takes it on appeal and goes back up to the Supreme Court, I think what we'll end up seeing, and you could rewind this episode, 24 months from now or so, when this all kind of relates, to each other, is the same way with civil presidential immunity. You have the Nixon versus Fitzgerald case, which said, Nixon, you could engage in this conduct while in office, wrongful termination to retaliate against a whistleblower, even though it's bad. That's the type of conduct that executives, that Article 2 empowers you to do, even if it's really bad. But in Jones versus Clinton, a case involving, sexual conduct or, whatever, private life stuff, that does not get to give you any type of civil immunity. And then we had the case before the DC Circuit in the civil context of Blassingham, which talked about campaigning and campaign activity being outside the realm of official presidential conduct. So in the civil context, if I was teaching that law class, I would say this has immunity, this doesn't have immunity, this falls slightly outside the outer limits. I think in criminal, we're going to see a similar type of thing. This gets immunity, this doesn't get immunity, as this works its way up through the Court of Appeals. Let's talk about what went down in sentencing and more. Let's take our first quick break of the show.
Even if you think it's a bit overhyped, AI is suddenly everywhere, from self-driving cars to molecular medicine to business efficiency. If it's not in your industry yet, it's coming fast. But AI needs a lot of speed and computing power. So how do you compete without costs spiraling out of control? Time to upgrade to the next generation of the cloud. Oracle Cloud Infrastructure, or OCI. OCI is a blazing fast and secure platform for your infrastructure, database, application development, plus all your AI and machine learning workloads. OCI costs 50% less for compute and 80% less for networking. So you're saving a pile of money. Thousands of businesses have already upgraded to OCI, including Vodafone, Thomson Reuters, and Suno AI. Right now, Oracle is offering to cut your current cloud bill in half if you move to OCI for new U.S. customers with a minimum financial commitment. Offer ends March 31st. See if your company qualifies for this special offer at oracle.com/legalaf. That's oracle.com/legalaf.
January is all about fresh starts. It's a great time to swap out the skincare products weighing your skin down in favor of a regimen that's scientifically proven to transform your skin at the cellular level, something that OneSkin, today's sponsor, knows all about. Their products are powered by OS1, a proprietary peptide that the four founders, who are all skin longevity scientists, developed after testing 900 other peptides. It's scientifically proven to switch off the aging, dysfunctional cells that cause lines, wrinkles, and thinning skin. Not only that, OneSkin's products are packed with nourishing ingredients like Andiroba oil, Brobanco, and Moringa seed extract to naturally boost collagen, reduce inflammation, and protect skin from environmental stressors while being free of unnecessary irritants like sulfates and fragrance. Ready to detox your routine, improve your skin, and look your best? Head over to oneskin.co and use the code LEGALAF at checkout for an exclusive 15% off your first purchase. Make 2025 the year you invest in habits that keep you and your skin healthier at the cellular level. I love OneSkin. I use it. I've been using it for a long time, and nobody can believe that I'm a 58-year-old grandmother. I attribute that to my skincare routine that OneSkin has been a part of now for more than a year. It was founded in 2016 by a team of all women scientists, and they did a lot of research, a lot of testing, and came up with this incredible product that I love and use. It's redefining the aging process with their proprietary OS1 peptide, the first ingredient proven to help skin look, feel, and behave like its younger self. Get 15% off with code LEGALAF at oneskin.co. That's 15% off at oneskin.co with code LEGALAF. After you purchase, they'll ask you where you heard about them. Please support our show. Invest in your skin and your health.
Welcome back to Legal AF. Thank you, everybody. I want to remind you all as well to subscribe to the Legal AF YouTube channel. It's growing rapidly. I want to see if we can get that channel 1 million subscribers. What do you think hits first? Legal AF at 1 million or the Midas Touch YouTube channel hitting 4 million? Or do you think they go right around the same time?
I like this challenge, and I want to compliment everybody. You and I, when we put together the idea for Legal AF before the election to have it be a durable, resilient, searing, analysis and channel after the election, and for all the good reasons that we've talked about, I did not envision, maybe you did, you're a visionary, more visionary than me, that we're going to hit 400,000 this weekend in our 4th month, 500,000 by our half birthday is our goal. And we just went over 50 million views of the content over on Legal AF, the YouTube channel, yesterday. Really want to thank all of our Legal AFers in Midas Mighty who have come over there and supported us as well.
Well, there's going to be a lot of legal cases probably starting on day one, where there's going to be needing a lot of coverage, and that's going to be the main destination. Although you'll get it on the Midas Touch channel as well, and of course here on Legal AF. Just a reminder as well, patreon.com/legalaf. Professor Popok's been posting some stuff lately there, so check it out. And Popok's going to be on there a lot. He's getting, as will I. Yep. And we're excited and we're grateful. We don't have outside investors, so it's one of the ways that we grow. It's those pro-democracy sponsors, as well as things like patreon.com/legalaf. Heck, we're beating competitors like Fox, who have $1 billion in revenue and billionaire investors and oligarchs. And guess what? We don't have all of that, but we've got you. We've got this community. We've got Patreon. We've got some pro-democracy sponsors. We're scrappy. We build. We grow together. Yeah. We, the Legal AF.
They don't have us, right? Like you just said, we don't have them, but they don't have us either, audience or contributors.
Exactly. Let's talk about what went down in the sentencing itself. We talked before the break how Justice Merchan really safeguarded the ability for sentencing to take place. He talked about how there would be an unconditional discharge, meaning Donald Trump would be proclaimed an adjudicated felon. It would be official because upon the sentencing, there's now a final judgment. I mean, look, he was convicted of felonies. So for you to say that he was a convicted felon before is not totally off base because he was convicted of felonies by a unanimous jury. But now it becomes a final judgment by the jury the moment sentencing takes place. And then Donald Trump's full appeal options now, take place if he wants to contest any aspect of it. One of his arguments, by the way, that will be interesting to read on appeal, Michael Popok, is he attacks Midas Touch. He attacks our hosts like Michael Cohen. He attacked you in one of his briefs saying that our podcasts and our shows were unfair and we prejudiced the jury against him. Then the footnotes, like 5 through 8, were all talking about our shows. I think it was page 15 and 16 of one of his emergency briefs. It was really weird when I was getting messages from family, friends, and Midas saying, he's blaming you for being convicted of felonies. I'm not sure how I will describe that one to my baby girl, my 4-month-old when she's older, but we'll deal with that in a few years. But Michael Popok, one of the things that Justice Merchan said is, while this was an extraordinary case in the sense of, the attention to it, the fact that it was the first time a former president was involved, he said there was nothing extraordinary about what went down in court. It was a normal case. Merchan said there were 30 other cases taking place in the courthouse at the exact same time. They all went through jury selection, voir dire. Witnesses were called, opening statements were made, witnesses called, closing arguments, motions, jury verdict, conclusion, and you were found guilty. There was nothing, while Donald Trump, Merchan didn't say this, yes, you all caps, witch hunt, unfair. This was the process that everybody gets. There was nothing different about the process. A jury heard all of the evidence and unanimously found you guilty of 34 felony counts. And it's also worth noting too, Popok, and you can see the incongruity of how disinformation can permeate versus what happens in an evidentiary system like in our court system. Because look, Donald Trump made gains in the election in New York. I mean, he still lost by not an insignificant amount, but he had, what was it, 35, 40% of the vote, maybe plus in New York. So that would have meant if you just took a cross section of 12 jurors, like 3 or 4 of them may have voted for him ultimately. If you look at just a random sample, 3 or 4, maybe 5 jurors would have voted for him. But when given the accurate information and understanding their solemn duty, removed from the disinformation silos of Fox and right-wing propaganda, when they just get the facts, they were able to come to the right conclusion, not just there, but in the E. Jean Carroll case and in all these cases against Donald Trump. Final point I'll make, then I'll pass it to you, is Justice Merchan said, the issue is the office of the presidency and not you as a person. Because I'm forced and compelled to respect the office, I can't give you the sentence that I want to give you because of the office, not the person inhabiting the office. It would be different if the office if you weren't in that office. But because the office exists, I can't give you a sentence to prison time. And because I respect the office, regardless of my feelings towards you, he didn't say it in those exact words, but essentially, I want the office to do well because we Americans need that office to do well. And that's how he ended it, saying Godspeed. That was basically it. Trump spoke for a little bit. He whined.
Wait. You're gonna let me say anything?
Yeah, of course.
Let me jump in here. Okay. So the sentencing was not as ordinary and garden variety as you just laid out, the Merchan's recitation of things. The sentencing, let's be frank, was not. If this was a garden variety sentence, the judge would have spent a considerable amount of time excoriating the person, just as he had done in writing in his prior rulings where he said, you haven't shown remorse, you haven't accepted responsibility. It was an extraordinary criminal act that led to the interference in an election. He didn't do any of that. He didn't do the judge part of sentencing. He was very tight-lipped. He said the bare minimum of what he needed to say in order to have all the magic language that you need to say in a sentencing occur to complete it, but really no more. It was word economy on display for a reason that I think our audience in the chat will be able to surmise, and I'll give you my opinion. But he colored well within the lines, Justice Merchan, including, as you said, tipping his hat at the end and going, well, the American people have saw fit to elect you twice. Godspeed with that, and then good, and then sort of good day. But that's not enough. I don't want people to come away, because we did both on Legal AF channel and on Midas Touch, we did post the full 27 minutes of recording. I don't want people to come away with, that's how a sentencing happens in New York. I practice in New York. That's not how a sentencing happens in New York. And the judge was very, very tight-lipped, more so than usual, probably because of all the other issues we've talked about. So it's one thing to say it is garden variety, but it wasn't. And you don't normally have a convicted felon zoom in on a 60-inch screen from Mar-a-Lago or Florida at his vacation home to be sentenced to something that he could have gotten up to 4 years. I was promoting a year and a half to 2 years after he served his first sentence, which was the sentence of presidency, but that he would serve more time in jail. So that's one. The laboring oar of wagging the finger at Donald Trump was left to Josh Steinglass for the Manhattan DA's office. He really served the role as president. I mean, as judge sentencing the former president. And so he did a fair amount of it, but even he was sort of not as bold as he would have been in another sentencing hearing. And then they let Donald Trump talk for a rambling 5 minutes. If anybody caught on Midas Touch or any other hot take any part of his recent Mar-a-Lago rambling press conference, the one where he couldn't remember how a kitchen appliance works or an appliance works, this was just it was about wildfires and Gavin Newsom, and then he got around to the case and started going, I don't blame Alvin Bragg because Alvin Bragg was just doing the bidding of the Biden administration. I mean, all sorts of crazy shit. The day before or the night before, he was busy Trump's posting on social media again, I'll go through this little charade. I'll do this little game they want me to play, this lawfare going after me. They tried to, he said it during the sentencing too, they tried to make me lose the election with this prosecution, but it didn't work. Ha ha. A lot of that. And then, so he was done. And to which Merchan just said, thank you, sir. It just sort of moved on and ignored it. Blanche said very little. Todd Blanche, who's going to be the number 2 in the Department of Justice in about a month, he said very little. So it was weirdly antiseptic. That's where the anticlimax comes from. So I thought, and I said this on a hot take, I thought this would be the opportunity that Merchan would take, not to get back at Trump, that's not the role of a judge, but just to do his normal job and just lay out the facts and the reasoning. He did explain why it's an unconditional discharge for those that are tuning in late to our democracy or to our network or channel. He's not going to jail. The judge is keeping on the books this indelible stain, felon in chief, first time in 249 years of our democracy, is going to be the president of the United States. So he is adjudged a felon. It will be in his obituary. It'll be in the history books, at least in the blue states. He's a felon. A felon who served no jail time, doesn't have to pick up trash on the highway, doesn't have to do any of that stuff, but the felon is the felon. Now he can go off, now that we're done with sentencing. Now the case is complete. Now there's a judicial decree, a judgment, a final judgment of which ends with the sentencing. The delay for the last 6 months, this should have happened 6 months ago. It's because Donald Trump kept filing motions to continue to get him over the election, past the election to the inauguration and all of that. But finally, he ran out of time, and even the Supreme Court didn't want to bail him out. His next role will be in 2025, as you laid out briefly. We'll take an appeal to a fully blown appeal to the First Department Appellate Division. These other things that he filed that you and I reported on, the Article 78 complaint against Mershon and against Alvin Bragg, where they sued him directly, and then an appeal. A lot of this falls. They're going to have to regroup now. First of all, Donald Trump is going to lose all of his lawyers because he's put all of his lawyers, from Alina Habba to Blanche to Emile Beauvais to Sauer, he's put them all in the administration in one way or the other. So now he's got to go hire another set of lawyers who are going to have to prosecute these appeals. So a lot of these things he did earlier are going to fall away because they're moot now. So now he's going to move to an appellate division, the Manhattan Appellate Court, for like the full-blown appeal, substantive merits appeal about whatever he wants to argue that Mershon did wrong. Oh, his daughter is a Democratic operative and he donated $25 to Democrats and he's biased, all this other stuff. He can do all that. And the evidence issues with the 2 levels of courts of appeal in New York. And if he doesn't like the result there, he can file a immunity request, writ of certiorari request with the United States Supreme Court through Sotomayor and try to get it there. Now, they didn't bail him out the last time on immunity when it came to E. Jean Carroll, because he lost his immunity decision to the Second Circuit that, no, you can't try me for sexual abuse and defamation because I was president during parts of it. And the Second Circuit said, no, you weren't, not during the parts that matter, and you waived it anyway. And the Supreme Court for the last year has said, nah, we're not touching that one. And they're not bailing him out on immunity there. So I'm not so sure they're that. There may be 4 votes, but I don't think there's 5 votes to rush back in year after year, moment after moment, to help Donald Trump out on immunity throughout his entire tenure of the next presidency. One last point. Listen to this language, Ben. I don't know if you missed it or I'm just telling it to you for the first time for our audience. Donald Trump complimented the United States Supreme Court when they ruled against him 5-4 on the sentencing issue and didn't stop the sentencing, even though MAGA is beating the crap out of Amy Coney Barrett, apparently, in their social media post. But he complimented them. He said, on balance, it was a good decision. And I don't blame them for that. Why? Because he needs the United States Supreme Court throughout the next 4 years, because he's going to be doing some outlandish abuse of power things. And he doesn't want, you see all the courts he abuses. He constantly abuses trial court judges and all. He's not abusing the Supreme Court because he knows he needs them and he doesn't want to be chastising them. In fact, why else does he want to pick up the phone on the Tuesday when he makes his filing on an emergency basis to have a conversation with Sam Alito, which now the Democrats are up in arms about and want him to recuse, which he's not going to do, to talk about a reference for a job applicant? Does anybody really believe that that's the topic of the conversation and it wasn't about Trump's return to power and things pending before the court related to Donald Trump? Come on. But this is the new world order that Donald Trump has fashioned between the presidency and the United States Supreme Court. And we're going to have to constantly keep track of it right here on Legal AF and the Midas Touch Network.
Michael Popok, what if sometime down the future you were a Supreme Court justice and I was in a powerful position and you were going to be ruling over a case involving me, okay? And we were great friends. And then we called each other. And you said to me, hey, how are you? And I said, I'm doing great. How are you doing? I'm doing really good. Hey, I really would like you to take a look at this applicant who worked for me. Think he's super bright, good guy. Oh, interesting. I'll definitely take a look at it. How you doing otherwise? Good. Okay, I'll take a look. Thank you. See ya. Even if that was the conversation, we just conveyed a lot of information without even having to say lots of things. What we conveyed is we got each other's, we're talking to each other.
I'm good, you're good.
Specifically, right. Even get on the phone and say to each other, hey, here's what we're going to do. We're going to collude and I got your back in all of these cases. Don't worry. Because you don't need to. When I handled collusion cases, And I think about some of the big antitrust and collusion cases I dealt, you would never find, rarely would you find a text message or a phone call or an email saying, we're going to collude and fix the prices. You didn't have to. All you had to know was that they hung out together at a trade association or at some event, and then you would link the nexus with an event that would happen that was favorable to the other person. And that would be enough evidence, implied collusive behavior. And when you look at the language about collusion in a legal sense, it's always described as expressed or implied. And most cases always involve implied, because people don't talk like, hey, sometimes Trump does. You heard Trump on some of those audio recordings before, but as it relates to, when he was showing people certain types of documents and things like that. Popok.
One comment. I want to illustrate that. Totally wordless. When George W. Bush came in to sit in the pews for Jimmy Carter's funeral, he had to pass Donald Trump, and he had to go over Barack Obama to sit in his seat. We have the clip. He completely ignored Donald Trump on purpose. He got to Barack Obama and tapped him playfully on the stomach, and then sat right down next to him. So much was communicated in that, even without words, about where people stood in people's minds and in their hierarchies, in just that half a second tap on the belly between George Bush and Obama. So of course the phone call with Alito, which of course we don't have a readout of, is completely ex parte inappropriate because of what you just said about the ability to communicate without, if somebody just read it, if we were like wiretapping this, like we're following, mobsters, they'd be like, well, yeah, how's the provolone today? Yeah, well, the wine is great, but the provolone's not as sharp as usual. It's all coded, but we know just the very act of having a warm chit chat while there's a pending emergency motion is wrong. I'll just one last thing. I still practice, so I'll go to a bar event where there's a room full of judges, including judges, and this is particularly true in Miami, which has a very small town environment. The state court judges run for election. You raise money for them. I know this is going to sound unsavory to some people. You will literally hold a fundraiser for a judge on a Friday. You will hand his treasurer a pile of checks, and on Monday you'll see them in court. Okay, but put that aside for a minute. If I see a judge that I have a case in front of, I don't even get into the chit chat. And they don't want me to either, because even if it's just like, hey, Judge, how you doing? Good. How's the cheese? How's the cheese puffs? Because another person in the public or that's related to my opponent could see that. And now they're off and running with an ex parte communication about a pending matter. There was Michael Popok over a glass of wine with Judge fill in the blank. And I don't want that. And judges, what we saw with Alito is that this court, Alito, Gorsuch, Thomas, operates like they're like they're Trump, and they're above it all, and they're infallible, and whatever they do is right, and they're doing some extraordinarily unethical things in plain sight.
Popok, when we get back, we're going to have to do a power 25 minutes because we spent a lot of time on these topics. We still have to cover the DOJ report, TikTok, and Giuliani. You think we can nail it in about 25 minutes? I think we can. Okay. A reminder, everybody, go check out the Legal AF YouTube channel. Make sure you subscribe there, and also patreon.com/legalaf. We'll be right back after our last quick break of the show.
Did you know 80% of resolutions fail by February? But you can beat the odds with Lumen and improve your health. Lumen is the world's first handheld metabolic coach. It's a device that measures your metabolism through your breath. And on the app, it lets you know if you're burning fat or carbs and gives you tailored guidance to improve your nutrition, workouts, sleep, and even stress management. All you have to do is breathe into your Lumen first thing in the morning, and you'll know what's going on with your metabolism whether you're burning mostly fats or carbs. Then Lumen gives you a personalized nutrition plan for that day based on your measurements. You can also breathe into it before and after workouts and meals, so you know exactly what's going on in your body in real time. And Lumen will give you tips to keep you on top of your health game. Because your metabolism is at the center of everything your body does, optimal metabolic health translates to a bunch of benefits, including easier weight management, improved energy levels, better fitness results, better sleep, etc. Lumen gives you recommendations to improve your metabolic health. Take the next step to improving your health. Go to lumen.me/legalaf to get 20% off your Lumen. That's lumen.me/legalaf for 20% off your purchase. Thank you, Lumen, for sponsoring this episode. Let's face it, I'm 59, and after a night with drinks, I don't bounce back the next day like I used to. I got to make a choice. I can either have a great night or a great next day. That is until I found pre-alcohol. Z-Biotics Pre-Alcohol Probiotic Drink is the world's first genetically engineered probiotic. It was invented by PhD scientists to tackle rough mornings after drinking. And here's how it works. When you drink, alcohol gets converted into a toxic byproduct in the gut. It's this byproduct, not dehydration, that's to blame for your rough next day. Pre-alcohol produces an enzyme to break this byproduct down. Just remember to make pre-alcohol your first drink of the night. Drink responsibly, and you'll feel your best tomorrow. Look, I won't lie. I was a bit on the fence about pre-alcohol initially, but then, while hanging out with some old buddies in Miami on a recent visit, I gave it a shot. And with them, it's a great dinner with cocktails and then lots of amazing old vintage wine, followed by cognac and cigars. So believe me, I'm here to tell you, pre-alcohol is the real deal. I got up the next morning raring to go and meet them for our annual basketball game. Go to zbiotics.com/legalaf to learn more and get 15% off your first order when you use legalaf at checkout. ZBiotics is back with 100% money back guarantee. So if you're unsatisfied for any reason, they'll refund your money, no questions asked. Remember to head to zbiotics.com/legalaf and use the code legalaf at checkout for 15% off.
Welcome back to Legal AF. Thank you to those pro-democracy sponsors. We're going to do a power 25 minutes, go through two topics. Michael Popok gave me a little crap for cannibalizing one of the topics, so I throw it back to you, Michael Popok here. The DOJ report being released. Donald Trump got a favorable ruling from Judge Eileen Cannon. No surprise there. She's corrupt. She rules in favor of him for everything, whether or not she even should have had jurisdiction to block the release of the reports. Remember, there's a volume 1 and volume 2 of this DOJ report. Volume 1, January 6th case. Volume 2, Mar-a-Lago document case. Different treatment by the DOJ in terms of how each is being released. There was then this appeal to the 11th Circuit. The 11th Circuit ruled. Michael Popok, power through it, big guy. But you have to have your mic on if you want to power through it.
Shit, I was so excited. I forgot to put on my mic. 5 minutes or less. Here we go. We've got smartly. Special counsel Jack Smith divides his world into two reports, volume 1 and volume 2. Volume 1, D.C. election interference, has nothing to do with Mar-a-Lago, has nothing to do with Judge Cannon, has nothing to do with the 11th Circuit. Volume 2, Mar-a-Lago, interesting. We now know two things about those reports. One, they were both reviewed in the second week in January by Donald Trump's lawyers, Todd Blanche and others, in a closed, sealed, hermetically sealed room in Washington, D.C., so they could do comments. Of course, none of them were adopted. All it gave Donald Trump was the opportunity to write a 15-page letter, which got attached to a filing by his co-conspirators in Mar-a-Lago and made public before the reports were made public. But that's just how the Democrats, when they run the Department of Justice, like to do things. What we didn't know, and Donald Trump's lawyers didn't know, is that when the special counsel sent the reports as statutorily required under the special counsel law to his boss, the Attorney General, Merrick Garland, he put a love note with one of them. The love note said, I recommend you don't release the Mar-a-Lago while there's a pending case there. The pending case is Judge Cannon, dismissed the indictment, finding for the first time in 249 years that a special counsel is not properly appointed as an inferior officer by the Attorney General. Has to go through a Senate confirmation hearing and a whole refunding program. Wrong. Up on appeal with the 11th Circuit. But she dismissed her case. No jurisdiction, as far as I'm concerned, to do anything else in the case. It goes up to the 11th Circuit, where it's been sitting for several months, fully briefed, with just the two co-conspirators, Nauta and De Oliveira, the maintenance worker and the butler of Donald Trump, who are still technically in the case. That's where it sits. So the recommendation which the Attorney General adopted is don't release Volume 2 while those two are potentially still going to be prosecuted. Donald Trump having been dismissed from the case because he won election. There's no other way to put it. And so he's definitely out of the case. So Donald Trump was sort of like the kid pressing his nose up against the glass of the candy store. Like, he wasn't in the case, but he wanted to manipulate all of the strategy. So he was having Nauta and Oliveira, for whose lawyers he was paying for, file all sorts of emergency applications with the 11th Circuit, stop the release of the reports. And with Judge Cannon, of course, they're going to go to Judge Cannon, who's going to do anything that Donald Trump says. And so two pieces of paper filed, two rulings. Cannon says, yeah, I think it's a good idea. Let's block everything, including the report that has nothing to do with my case. And we'll keep it as a block until 3 days after the 11th Circuit gets around to addressing the emergency stay that was issued to them. Now, she didn't have to do that. If the 11th Circuit wants to stay something, they can stay something. The DOJ files their own opposition to that through the U.S. Attorney's Office in Miami and says to the 11th Circuit, release the reports, and we're making it easy on you. There's no issue here with the Mar-a-Lago case. We're not releasing the Mar-a-Lago report. We're only releasing the D.C. election interference report, which is Judge Chutkan anyway. It has nothing to do with these two. It may have something to do with Trump, but he's not in this case. So they argued that. The 11th Circuit agreed and said there's no reason to block the release of the report. I would interpret it as both reports, but at least the report about DC election interference. They didn't address the 3 days, which was weird, mainly because the Department of Justice, frankly, didn't ask them to. And so they said, to kind of clear up this procedural hiccup, they told in their order Jack Smith's team, or the Department of Justice, and if you want to get out from under the 72-hour thing, file an appeal, and we'll take a look at it. Now, there's this gap from Friday to now. We're already on Saturday, and I looked before recording, or before our live. There's no movement yet by the 11th Circuit. If they don't make a ruling, even though Jack Smith has filed the appeal that was requested of him, to appeal the 3-day, 72-hour hold on the report, Sunday's going to come and go, and that report's going to get released Sunday night. You and I will jump on some emergency legal AF, or Monday morning, to the American public. It's ready to go. I mean, that's the implication I got from Jack Smith reporting in his filings, that it's with Merrick Garland. He's ready to release it. He was ready to release it, I think, on Friday. So it's ready. It's going to be 500, 800, 1,000 pages. And the smart thing I'll leave on this, Ben, the smart masterstroke, and you and I can spend, and we will probably when we catch our breath, like we could spend an entire show critiquing Merrick Garland. And how that didn't really work out the way we wanted to. However, occasionally, he's brilliant, or at least Jack Smith is. They have decided, you can tell, that Mar-a-Lago was going to be the report was going to be the sacrificial lamb. In order, it was like you were playing football, it was like the fake in order to throw the long ball into the end zone, which is the DC election interference case, to get that out to the public. That's the one when they're ranking it, if they, like Sophie's Choice, they could only choose one. They wanted the DC election interference case report to come out to the American people because it goes to the heart of our democracy and Donald Trump's interference with the peaceful transfer of power. Mar-a-Lago is interesting. Lord knows I've learned more from you about SIPA than I ever want to learn. I almost named my daughter SIPA. It was so interesting. However, It didn't have a lot of moving parts. It was about a post-president hiding docs, which we all saw. We all know it happened. We know about that. We saw the photos. Like, we know about that case. DC election interference. There is stuff in that report, I presume, we have not seen, have not heard of, and they wanted that. So they are sacrificing. We'll never, let me manage expectations. We will never see Mar-a-Lago.
I disagree with you. I disagree with you.
There's no way. You mean through a FOIA?
No, I mean, I think that there'll be classified portions, but I think there'll be portions.
Who's going to release it?
Well, it's being handed over to the ranking members in congressional committees. So it's not getting deep sixed. It's being turned over to the head of I believe, the Intelligence Committee in the House of Representatives, the chair, a Republican, the ranking member, a Democrat, until such time as the case against De Oliveira and Walty Nauta gets dismissed. The moment the case the reason why that report is not being released is not the SEPA issues. That can be, it's one of them, but that can be dealt with via heavy redactions. The reason it's not getting released, and the best argument not to release it, is there's still a pending criminal case against Trump's co-defendants that are on appeal, and it would prejudice their rights because technically they still have a presumption of innocence, even though we all know Trump's going to pardon them or they're never going to serve a day in jail. So what it actually forces Donald Trump to think about is, am I going to have my DOJ dismiss the case against Walty Nauta and De Oliveira, at which point that could actually trigger the release of the report that gets in the hands of a Democrat in the House of Representatives, the ranking member, so it's not totally deleted and removed from servers. This thing will exist. And so then the fight becomes the release of it. And what we know is that the report at least gets out. So the brilliant move,
I disagree. Wait. I'm going to debate you. My understanding, and you and I could debate it here and on Hot Takes, is that Garland is not sending the Mar-a-Lago report to Congress.
Oh, I believe he's sending it to the, unless I read the 11th Circuit paper wrong, my view is that what Garland said was that it's not an emergency because we're not releasing it to the public. It's going to go into the hands of the 11th. It's going to go into the hands of just the ranking members, and therefore all of Donald Trump's concern about the imminent publication, he has nothing to worry about. And that's how I agree
with you if you're right. But my understanding, and I read it too, the 11th Circuit brief, is he's not even turning it over, which means if I'm right, and we'll figure it out, if I'm right, then it goes to the next attorney general to make the decision, and it's tanked. If you're right and it's already going to be released to the Congress with a love note that says don't release, see, that's the problem. How do you, and that was the leak argument that, and I attacked, that the lawyers for Oliveira and Nauta were raising. I was like, it's not even going to Congress, so there's not going to be a leak. But we'll get to the bottom. That's why people tune in.
You hit TikTok. I'll take a look right now. You hit the TikTok case. What happened there? TikTok is likely going to be banned. All right. Here's what we know about TikTok, and I'll pass it over to you.
Yeah, okay, good.
Whether the right-wing justices, the left-wing justices, however you want to describe them, they all seem to recognize that they all feel that TikTok is a national security threat. You had everybody from Justice Kavanaugh on the right to Justice Ketanji Brown Jackson on the left, attacking TikTok from different sides. TikTok basically argued, First Amendment, we have the right to, have people, watch our content. And then the response to that is, there's an override. Whether you view this as a strict scrutiny thing or whether an intermediate scrutiny, it doesn't really matter which scrutiny you look at it. Congress, the Senate, on a bipartisan basis. And what do they ever do bipartisan, right? They made findings that TikTok, one, uses its algorithm to cause harm in the United States, but two, they use their software and their app to conduct surveillance on the United States. So it's a national security situation. Congress was right to pass this bill that was signed into law. There shouldn't be any issue here at all. I think the one little caveat that they were musing over is, is it possible that even though we ban it, you can basically say that still Trump can't enforce it? Like Trump can not penalize the app companies like Apple for violating the law. Potentially, is that a way around it? And I still don't think they get there, but I think there were some right-wing justices who were wondering, can we do anything here to kind of make Trump look like a savior, even though, by the way, it was Trump who started this whole process. Trump was the one who originally wanted to ban TikTok. The original lawsuit was ByteDance versus Trump, the parent company of TikTok. Popok, take it away.
So I took a look at the briefing while we were waiting. He's going to release it. We're back to the report. But he says this is the filing by the Department of Justice. But to avoid any risk of prejudice to Nauta and Dal Viera, the attorney has determined at the recommendation of the special counsel that he will not publicly release Volume 2 as long as those criminal proceedings remain. For the time being, Volume 2 will be made available for in-camera review only by the chairman and ranking members of the House and Senate upon their request and agreement not to release any information from Volume 2 publicly. So your position is that after this is over, since it's already with the ranking members, that they'll be able to get it out. Is that it?
So I think that we were both somewhat right in the sense that what it doesn't say is that what we don't know is that the in-camera review, this private review, will they ultimately get access to the report and physically hold it? Right. They will get to read it and know about it and talk about it, what's in it. Will they get physical custody over the report? And so you and I were both kind of right. It doesn't seem like they're going to get physical custody to hold it, but they will have access to it. And so it will be siloed at a place where they can always access it so that it won't be deleted. We're both right.
Okay, you're right. All right, that's good. Well, that's why we love the show. I learned so much from the show. TikTok. Yeah, I agree with you. I think there's nobody that could listen to the oral argument and think that TikTok is going to win this. The problem is the lawyers for TikTok, and they brought in the content creators from TikTok too, because they want to make this a First Amendment argument. 170 million First Amendment rights for Americans who love using the platform. Okay. And I think the Supreme Court, by and large, the majority of them understand that there's First Amendment implications by this. But what the ByteDance lawyer could not look the justices in the eye and declare is that TikTok, through ByteDance, is not ultimately controlled by the Chinese Communist Party. And by doing that, once he couldn't say that because it's not true, then even the right wingers, and you and I anticipated this because a week ago, when Roberts issued his annual report, he had a whole section in it, and he knows what he was doing, and he knows he was issuing it before the TikTok oral argument, in which he said one of the threats to democracy is foreign power interference through misinformation and disinformation campaigns in our society. And I'm like, oh, here we go. So Roberts, Kavanaugh, Amy Coney Barrett, Alito all jumped all over the ByteDance / TikTok guy, lawyer, and asked way more questions of him and a very hot bench. And fundamentally, they were like, Kavanaugh, I think, led the way with, why would we ever want a foreign enemy power to be able to, at a flip of a switch, collect data and information and data mining about Americans? And then he took it one step further. He said, Americans that may be teenagers and young adults now, but a generation from now are inside of our FBI and CIA. It's a very smart argument, by the way. You know, it's not just all the things that TikTok is being used for today. It's you're giving your information and the Chinese government now knows about you, and now you're a spook. Now you're working for the company. Now you're in the CIA. You're in the intelligence community, and that's a problem. And so they focused and drilled down on that. And of course, the TikTok guy, he can't respond to that because the Chinese government wasn't there arguing, right? Where's the lawyer for the Chinese government? Okay, we're not good. That's his problem. So they could only make this about the First Amendment. And Kagan or Soto, I think it was Kagan. Kagan was like, we got it. We got the First Amendment. There's a reason we don't want foreign powers controlling news media. And the guy said, well, Politico is owned by Germans. Yeah, but not the German government. And a German billionaire doesn't count. We got our own billionaires to worry about. So there's no way you could come away from the oral argument believing that TikTok is going to not survive, not be forced to sell. Even Amy Coney Barrett and Alito joined together in a twin argument in questioning. Amy Coney Barrett's like, what are you fighting so hard for? Why don't you just sell? Just sell and you've solved your problem. You don't go dark. And Alito was like, yeah, and if you don't sell by the 19th and you go dark, could you turn the lights back on a few days later after there is a sale? And that's okay too. And the lawyer had to say, yeah. And so they were like, oh, so you can, the 19th is not it's not a death penalty date. It's a date when we could revive you later on if, put you on ice for a week or two. They got into the discussion, which is always scary, about the executive branch, i.e. Trump, not enforcing the law, which is another thing that John Roberts says he was worried about in his annual report, which is the executive branch ignoring and flouting the ruling of the Supreme Court and not enforcing it. That's a problem. You don't have desegregation in schools unless you have the will of JFK and RFK to send in federal troops to desegregate and enforce the law when the states were rebelling. So they asked that question, almost like, I don't know, it was Gorsuch. It was something like, well, what happens if they asked Preliger, the current Solicitor General for the Biden administration? They said, well, what if the president doesn't enforce this? In other words, there's the forced sale requires the sale to a non-Chinese buyer, or lights go off, like fines by the FCC, all sorts of fines. If you put it in the App Store, if you have it on your phone currently, you're not going to be a criminal, but you won't be able to download it. They won't be able to update it, with all the algorithmic stuff on there. So he said, so what if Trump doesn't, he's already filed a brief, although it was mentioned very, very in passing. What if the president doesn't enforce it? Then what? And she had to admit that this has to be executed by the executive branch. Otherwise, what are you going to do? So that's what you and I have to keep an eye on closely, is Donald Trump has already sent in a brief that said, let me broker this and I'll handle it when I get in. Just issue a stay. I have a question for you. Do you think they issue a stay to see what happens once Trump gets in, or they do their job before the 19th and issue their ruling?
They'll do their job, whether it's before the 19th. I mean, that's when the ban takes place. Mm-hmm. I'm thinking if it'll be on the 19th, on the 18th. But
you think they do it?
I think they do it. I like, they didn't. To your point, they didn't even address Donald Trump's amicus brief. It was like, all right, shut up. All right, what is this? Like it was another example though where Trump was trying to. I'm a deal maker, Supreme Court. I'll do some deal here, right? The same way you're brokering peace in Ukraine and Russia, you freaking liar. And Supreme Court didn't even talk about it. Like it was just some piece of paper that a 5150 pro se person sends their way, that they get all the time, and they're like, all right, I'm not even looking at this. Popok, final topic, Giuliani. Break it down quick. He doesn't deserve a lot of time on this network, but it is funny when he gets held in contempt over and over again. I mean, he's been making these posts during the contempt hearing before Beryl Howell, calling her bloodthirsty. Like he, massages this bloodthirsty women with fangs is coming after me. And I told you how bloodthirsty she is. She hates my, and it's like a Trump post. But when Giuliani's doing, but it's not Trump. And by the way, it should not be acceptable when Trump does it. But give us about 90 seconds.
Yeah, give me 95. Here we go. He was found in
negotiation.
Thank you. He was found in contempt on Monday by Judge Lyman, and he's going to lose his Mar-a-Lago adjacent condo as a result to Ruby Freeman and Shay Moss. Fast forward to Friday, he's forced to go on because he breached his consent decree, which is a type of judicial order by Judge Beryl Howell in D.C. in the underlying case brought by Ruby Freeman and Shay Moss for defamation and punitive damages, because he horribly defamed them and caused them emotional distress because he said they were fraudsters and committing voter fraud when they were doing nothing of the kind. And so the jury whacked him for $148 million. They've been chasing after his assets ever since with a nice law firm in New York that's doing it all for free to maximize the recovery by those two. He's going to lose the condo there. This issue was about whether he breached his consent decree, his order that he would not continue to bash them and defame them or they were going to continue to sue him and go for more damages. So he said, he said, enough, white flag, I'll sign the order. So he signed the order. And then whenever he runs out of something to say on his podcast, and I've seen the podcast now twice, I think I was the third or fourth viewer of it, he bashed Shea Moss and Ruby Freeman again with the exact same way. They were passing a thumb drive like it was heroin, flipping votes, same effing thing as in the trial. Breach, contempt. That's a contempt of court. They drag him in. He doesn't want to go because he's sick and he's got to go to the inauguration and whatever. She says, there's no medical excuse. You can travel. You're in my courtroom. He comes into the courtroom. He doesn't like it. So he starts tweeting, social media posting the night before and in the courtroom about how she is a bloodthirsty judge who is out for the Jan 6 defendants. He's got to tie that in there. And she's making me wait all day. This is not the strategy. Don't try this at home, by the way. We try to give good tips about how to run your life if you ever end up in the court system. Don't do this. So he's tweeting in the room about her. And she finally issued her order, found him in contempt for violating 6 different ways her order. And then I'm on the edge of my seat. I'm like, okay, here we go. Jail. Because fines aren't going to work. He's got no money. There's no adverse inference. There's no other proceedings. Jail. Say the word with me, Judge. Jail. And she almost got there. She said, I'm going to have you fill out another order. I'm like, oh, we got it. This is like a Russian nesting doll. There's an order inside of an order. Yeah, you're going to do another order. And you're going to concede that Ruby Freeman and Shea Moss didn't do anything wrong, that they've been cleared, and some other factual things he has to agree to, and you'll sign it. And if you violate that, I'm like, okay, now it's jail. I may send you to jail. What is going on this week with this lack of sentencing? So that's where it was left. I was waiting all day for I was waiting to do a hot take on it, waiting all day for the final thing. And that was it. So I have to keep following up. I think he's going to sign this thing. I think he's going to violate this thing, and I think he's going to be back in front of Beryl Howell and maybe get jail then. Let me just leave it at this. It's hard in a civil contempt arena on the first strike, the first violation, to get automatically thrown in jail. I understand that. But she's progressively disciplining him, hoping that he'll, like another tripwire, he will F this up. I think she has no doubt about that, and the lawyers don't either. And so if he screws it up again and he violates this order, I think we could be looking at jail time for Giuliani in 2025.
Yeah, I think the most important things for Ruby Freeman and Shea Moss, though, in addition to, potentially Giuliani going to jail, is that they get their money. It was $150 million or so verdict. The way they're trying to collect upon that with Giuliani's apartments and all of these things, I think that what Beryl Howell wants to be careful of is tripping up, get these ladies the money that they deserve and drain Rudy of every single penny and every asset that he has, because that's going to ultimately sting Rudy probably, even more, and not just Rudy, but future generations of Rudy based on his where that money would otherwise go to his estate. We covered a lot of topics today, everybody. I want to thank you all for your wishes. I'm grateful for everybody's support. And my heart aches for all of the people out there who are still suffering as a result of these fires. Those who are still in the zone of danger. Horrible stuff. And we stand with you. We're with you. And I wish there was more that I can do than just be on the show, and do this. But I think that there still is some importance of getting out factual, accurate information when the right wing is flooding the zone with disinformation. Thank you, everybody, so much. Michael Popok, always a great time spending this weekend with you with the Legal AF. As a reminder, check out the Legal AF YouTube channel. Make sure you subscribe there. It's a great YouTube channel. Popok has many daily hot takes there, and sometimes we can't cover them all on the Midas Touch channel. So that's the place where you can go to get all that legal updates all the time. Also, patreon.com/legalaf, patreon.com/legalaf. We don't have outside investors, so it's a great way that you can help. Also, thank you to our pro-democracy sponsors. The discount codes are in the description below. So you just take a look at that description. You'll see all the discount codes. They help us out a lot, those sponsors. They help make the show a possibility, and it's great stuff. So thank you, everybody. We'll see you next time on Legal A. Shout out to the Midas Mighty. Shout out Legal A afterwards. Have a good one.